Welcome to Wills, Estates, and What Comes Next, Probate Insights with Jamie Cuzmar.
Welcome to Wills, Estates, and What Comes Next, the podcast where Florida families get clear, compassionate guidance through estate planning and probate. We are your hosts, Sophia Morales, here with attorney Jamie Cuzmar, founder of Cuzmar Law Firm. Whether you're planning ahead or navigating the legal process after losing a loved one, this show is here to make complex topics feel understandable and manageable. Now, let's get started on today's topic, estate planning FAQs, your top questions answered. So, Jamie, what is the number one question you get when someone calls about estate planning?
The number one question that I receive is what's the difference between a will and a trust, and what are the pros and cons of each? So that one is primarily the question I get, although I get all kinds of questions. So I go on to explain what the pros and cons of each are. And of course, I apply that to their situation.
So we hear these words thrown around, and I know a lot of us aren't sure what they actually mean until we've been down in those weeds. So can you break down the difference between the two with a simple example, maybe something you frequently see with your clients?
Yeah, absolutely. The biggest difference is that all wills, if that's all the client has or the person has, all wills have to be approved by the court. All wills have to go through probate for the most part. There are specific wills that don't have to go through court, like a pour over will, and those are generally aligned with an actual trust. So the difference between a will and a trust is that a trust is like a will on steroids in that it has additional legal language in it to avoid the probate court. It's essentially a contract between the person and their own assets, and they get to dictate how they want the assets to be distributed when the time comes. And versus a will, you can still mention what you'd like to happen, but it still has to be approved. And it's not that the judges are not looking to approve these things. They want to go ahead and abide by the person's wishes as much as possible, as long as it's legal. But to avoid that extra step of having to go through probate court, the loved ones are usually in a better situation when they inherit stuff through a trust versus a will.
So who needs an estate plan? I know a lot of us tend to think, oh, well, that's a fancy thing. And it's just me and my kids and the house and the car and the spouse. And when should you start thinking about doing one of these?
Yeah, I would say an estate plan is a kind of a general term, right? So it can encompass a variety of things. I would say that I try to differentiate people between either a will plan or a trust plan. So people that have multiple assets or multiple homes are generally better suited with a trust, because they could even put properties from other states into the same trust. Even though a trust is created, say, here in Florida, and they have another property from a different state, they can still add that house into the control of the trust here, and vice versa. If somebody has, say, a trust based out of New York, they can put Florida properties into that same trust. It just really depends where they're a resident of, or where they have the most ties to their assets. And
at what point should we start thinking about making a choice between like a will plan and a trust plan?
yeah, so in a will plan, people should start considering it maybe when they have loved ones that they're concerned about. So the whole point, or my philosophy, is you want to leave the next generation better off, and that estate planning is well suited to do that. So really, when I would say you have someone you care about, it doesn't have to be necessarily children, but maybe grandchildren or other family, other siblings. If you feel like you have enough stuff to protect and have enough stuff to pass on, then yeah, definitely get started with an estate plan. If you have at least one house, a lot of times people will not know that they can pass on a house, especially in Florida, through something a little simpler called ladybird deed. So ladybird deed is something that allows you to bypass probate and passes on somebody's house right away upon their passing. So it's a beautiful tool that Florida provides. It's one of 5 states that allows this type of deed. And so for people that have just one house, but maybe don't have much else, then they're well suited for a ladybird deed, at least in the interim. Now, as they start accumulating more stuff, maybe they can pivot and create a trust after the fact. But the idea is to protect what you have now under your current situation. And then, of course, a lot of this stuff you can go ahead and amend or update if you need to.
And what happens if someone dies without a will in Florida?
Well, it still would involve probate, but there's two different types of probate in Florida. Primarily, you have a formal administration of probate, and then you have a summary administration of probate. So those are based off of how long the person's been deceased and how much assets are involved, the value of the assets. Now, the question being, what happens if you die without a will? You're either going to go through a probate process intestate, meaning that they had no will, or
Yeah.
testate, meaning that did have a will. So the biggest thing is that if they die without a will, they really have no control over the distribution scheme that Florida has by default. Most of the time, the distribution scheme by default is normally what people would want anyway. Meaning, like if somebody passed away and they had a spouse, and their spouse is next in line to receive the assets if they weren't already under the control of the spouse or a joint account with the spouse. Next would be children of that family. So there's no spouse, but they had children. The next in line would be the children. So the difference with the will is that you can dictate and change that distribution scheme a little bit to an extent, depending on your situation. And you could also, add other variables in there in case. So some wills, for example, will talk about vehicles, whereas if you die without a will, you can't necessarily include that. Other wills will talk about what would you like to happen as far as a burial or cremation. So without that, you don't have kind of the same say so or same control. You kind of be left up to the judge and your family deciding those type of things for you.
Mm. Yeah, and it may not be what you had in mind.
Right.
Yeah.
Right.
So some people think estate planning is basically for the wealthy. How many assets do you need to have before you start thinking about doing something formal about this situation?
Yeah, great question. So I take it during the sessions with the clients or potential clients, I'll tell them, hey, there's a lot of assets that are exempt from probate. So if you have only a bank account and say life insurance policy or retirement account, those things are generally exempt from the court system as long as there's a beneficiary listed on those accounts to receive those assets upon your passing. So I caution people all the time, say, hey, if your beneficiary forms have not been updated, definitely pay attention to that. Or if somebody passes away that was a beneficiary on those forms, go ahead and add somebody else at a minimum, right? Because if you
Yeah.
don't do that and there's no beneficiary to receive that asset, then it's going to automatically default to probate. And so you might have a beautiful estate plan with a trust. But if the trust doesn't have, for example, control over that asset, it doesn't matter. It's not going to be able to be managed through the trust. So one thing I tell people is to list their trust as a contingent beneficiary on all these accounts as well. It's very commonplace to list your spouse first if you're married, or your children if they're adults, to list them as a primary beneficiary on several accounts. But I would say if you're going to take an additional step, I would normally recommend that the person add the trust at least somewhere along the line on those accounts as a contingent beneficiary, so that if
Right.
they all pass away together, for example, disasters happen, or car accidents happen all the time here in
Yeah.
I-4. If people pass away together and you pass away with a beneficiary listed, it's a good idea to have a contingency in place. That way it can still avoid probate if you set it up correctly.
Very good. And after someone's had a conversation with you and kind of set up their plan, how often should they look back at that and make sure that nothing needs to change?
Yeah, on average, I would say every 2 years, 2 to 3 years. For my trust based clients, I do give them the option to meet with me every year. And that is more so to follow up and ask them, hey, have you done this? Have you named the beneficiaries in these other accounts? Have you added your trust as a backup beneficiary on these accounts? So usually I'll use this session as a reminder and just to catch up. But beyond the 2 to 3 year window that I would say it's a good idea to revisit, if you have a change in your situation or your life or your marital status or additional children, then it's a good idea to touch up sooner.
That would make sense. So, what are some common mistakes you see people make when they're trying to DIY their estate planning and save a couple bucks?
Yeah, I mean, we live in the world of Google search and looking up things on your own, and I'm definitely not immune to that. I like to look up things myself, and on things other than estate planning, like how to fix something. I'm all about trying to do things on my own as well. But the biggest mistake that I see people making is adding their children to the deed or the title of their house, because
Mm,
that will automatically remove some protections that are in place. Think
Oh, are we
liability.
talking about like the homestead exemption?
Right, right. So it doesn't remove the homestead exemption, but if you add a child, let's say, to your deed while you're still
Sure.
alive as a current owner or a joint owner, then all of a sudden they've lost the benefit of a step up in basis. So I tell people it's
Oh,
always better to inherit property versus gifting it away. It's better to inherit property from your parents, for example, than them adding you on the title as an existing owner. Because, for example, a parent might not realize. I think it's a good idea to shortcut the process. And yes, you can add somebody as a current owner with you, but then later on, you're going to need that person to authorize any changes, like refinance or even sell the house.
right.
You'll need their permission, and people don't really always think about that. So it's better to
Right.
leave it either in a ladybird deed with the child or whoever you want listed as a beneficiary, as long as it's legally allowed. And there's things that I'll get into a little later about who you can add as a beneficiary and who you can't, depending on the circumstances. But yeah, certainly I educate people on, what benefits are included with inheriting a property. So think capital gains taxes. Those kind of things are better suited if you inherit a property, or to your advantage or the loved one's advantage versus just giving them the asset control outright while you're still alive. And then also by adding somebody to the title of your home, then all of a sudden, if they're under a lawsuit, then their share or their portion of that home is
Yeah.
exposed. So
Yeah, that I didn't even think of that, but you're right. Yeah, if they get in an accident or something and somebody comes after them, you suddenly might lose your house.
yeah, and here's
Yeah.
another scenario. For example, if you add your son, for example, to the title of your home, because maybe you're up there in retirement age, and you're just wanting to make sure that your children get the house. So a lot of people do that just kind of to sidestep the process and make it a little bit quicker, right? But all of
Right.
a sudden, let's say your son that you've added to the title of your home passes away, and he's married to somebody. Then all of a
Oh,
sudden, that spouse
no.
that you had no intention of having any say so with that property has a say, or they can claim a share of that property because
Yeah.
their husband was on the title.
Yeah. Oh my goodness. Yeah, the things you don't think about. So I guess that brings me back to this ladybird title. Who can you put on there and how does that work?
Yeah, so the homestead laws in Florida are very specific about who you can pass a house or homestead in particular, specifically to somebody else. So if you're married, you can't give it away to somebody else unless you allow them or they allow an exemption. So you can build in an exemption and put proper language in there saying, hey, my spouse is okay with this if you want to go ahead and not leave it to your spouse. So there's an option that you can, but technically speaking, most of the time you don't want to leave it to anybody else. And if you have minor children, say you're not married or maybe you're divorced, but you have minor children, you can't give away the homestead to anybody but your minor child. So the idea there is the homestead laws are there to protect the family and also to see that there's some continuation with that property. So Florida is great in that it does believe that everybody should have somewhere to live. So they don't want to they want to make sure that if there is a minor child whose parents have passed away, have some protections in place there. And so that's why those laws are set up the way they are.
Very good. Well, that was very informative. Thank you for all that insight.
Thank you, Sophia.
And thanks for listening to Wills, Estates, and What Comes Next. If you found today's episode helpful, be sure to subscribe, leave a review, and share it with someone you care about. For more information or to get in touch, visit www.cuzmarlaw.com, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.